Juntamente, convidamos o palestrante Dr. Richard Meyer. Professor Richard Meyer é diretor do programa de mestrado da Faculdade de Direito do Mississippi e membro do corpo docente adjunto da Faculdade de Direito de Colômbia, onde ministra cursos sobre Direito Militar e Criminal. Foi professor de Direito associado da Academia Militar dos Estados Unidos, em West Point, de 2007 a 2011, e professor adjunto da Universidade de Maryland e da Universidade Internacional de Western. Também lecionou na Escola de Inteligência Militar dos Estados Unidos. De 1993 a 2006, atuou como Judge Advocate do Exército Americano nos Estados Unidos, na Ásia e Europa. É mestre em Direito e atualmente está completando seu doutorado em Ciências Jurídicas na Universidade de Columbia, sobre o futuro da jurisdição militar. É autor de diversas publicações e já proferiu inúmeras palestras nos Estados Unidos e em outros países como China, Alemanha e Holanda. Professor Dr. Richard Meyer trará uma palestra sobre o tema Uma comparação básica entre o sistema da Justiça Militar americana e o da brasileira. Senhoras e senhores, com a palavra, a presidente da mesa.
Bom dia a todos. É com muita honra que retorno a esse tribunal, mais uma vez como presidente de mesa, e tenho a honra de presidir esse painel sobre uma comparação básica entre o sistema de justiça militar americano e o do brasileira, que acho que vai nos enaltecer e esclarecer várias questões, mesmo porque tem sido um crescente, um desenvolvimento de ideias sobre a justiça militar nos Estados Unidos, e agora, nos Estados Unidos da América, e agora nós vamos ter uma comparação que provavelmente vai nos tirar dúvidas, enriquecer e nos dar uma visão dessa questão comparada, que tenho certeza que vai enriquecer mais ainda esse seminário. De qualquer forma, gostaria de agradecer na pessoa da ministra Elizabeth, do presidente desse tribunal, sempre o convite honroso de estar aqui. É uma honra poder estar nessa corte, a primeira corte desse país, a primeira corte é da habeas corpus, e quem conhece a história da justiça militar sabe a importância de poder estar palestrando e falando para esse público tão seleto. Por favor, com a palavra, o professor Richard Meyer.
Thank you. Good morning. I'd like to start first by thanking the president of this fine court and, of course, the vice president for having this wonderful conference and giving me the opportunity to talk to you a little bit more about the United States system as it compares to the Brazilian system. Now, I come from the great state of Mississippi. I had been to all 50 American states, and the last one I went to, Mississippi, is the one I retired in. Now, there's three things that Mississippi is probably best known for. The first, it is the home of America's music. Blues, jazz, and even rock and roll find their roots in the state of Mississippi. The second thing that Mississippi is known for is its great southern hospitality. If you ever have a chance, you will see that when you visit, it is known as the hospitality state. We will welcome you. We are very warm public. I, of course, say we now because I've been there for 2 years, so now I'm a local. The one thing I haven't quite adjusted to yet, though, and that is the third thing Mississippi is known for, and that is having a colorful way of saying things. You see, where I would say that my talk today is a comparative analysis of two different military justice systems, analyzing the best way to preserve discipline and justice in the face of combat, a Mississippian would say simply, there's more than one way to skin a cat. Now, at first glance, you think, why would anyone ever want to skin a cat? And that always troubled me. But then I realized as with most things, the Mississippians are thinking deeper than I, because the most famous cat skinned in history was the Nemean lion, skinned as the first labor in the Greek mythology of Hercules. And if you remember, the labors of Hercules were known as near impossible tasks. And so when I think about it, that's kind of what we face. Preserving discipline while staying dedicated to justice in the face of impending death, that is the most difficult of tasks, and it is truly near impossible. And it is a great labor that both of our military systems and our judicial systems struggle with and are constantly working at and trying to improve. Now, yesterday, your day started with Dr. Gonzalez saying that he was surprised that a reserve officer, a reserve field artillery officer that was a second lieutenant, was there giving a talk about military justice. And I found some warm similarities because I was, in fact, a reserve second lieutenant in field artillery before I went to law school and then proceeded with my JAG career. As you can see, the purpose that I have for you today is basically to intro our system to practitioners of the Brazilian system and try to draw some comparisons and differences. This is my outline for today. I'm going to give you a very brief, you've already gotten most of it from our other speakers, a very brief history of how our military justice has developed, and then I'm going to talk about what I think are the 5 areas that are the best basis for comparison between the United States and Brazilian system. Those are status-based jurisdiction, holistic military justice, the prominent role of commanders, the adversarial due process, and a segregated system of criminal appeals. As Colonel Maxwell noted, we had a separate system of military justice before we had a country. 1 year even before the Declaration of Independence was the first time we had articles of war that defined offenses and authorized the court-martial of those who violated those offenses. When our Constitution was formed, they stayed dedicated to the same philosophy of a separate system of justice. In fact, other than the crime of treason, the only true, and the international crimes such as piracy, the only criminal system that Congress was originally authorized to develop was a system of regulations for the land and naval forces. In 1951, as Colonel Maxwell's already told you, we went through a complete renovation of our justice system. Because during World War II, we certainly had quick justice, but it was not very consistent, and it was not very credible. And they said, if we are going to be a system that promotes freedom, that protects freedom, we must have a justice system that embodies those concepts. And the most recent version we have today is the 2012 Manual for Courts Martial. Now, I have actually with me the 2008, but it would be identical. I show this to you. It is, for lack of a better word, this is our Bible in terms of American military justice. Everything that matters to us is found within this book, as far as statutory or codified law. Then, of course, as you know, we are a common law system, so such as the opinions that Judge Baker writes supplement this law and interpret it and tell us how to use what the meaning of specific phrases and words are within the book. Now, the first area I wanted to talk to you about is status-based jurisdiction. This is a huge difference between our systems. As Colonel Maxwell said, it's universal jurisdiction. Think about what this means. Every soldier, every person on active duty in our military, no matter where they are, no matter what they are doing, and under whether they are on leave or on duty, is subject to the Uniform Code of Military Justice. And you will find that virtually every action they could commit that would be viewed as criminal or improper could be charged under the Uniform Code of Military Justice. Now, historically, jurisdiction in the United States requires both personal jurisdiction and subject matter jurisdiction. And we had a case a Supreme Court case called O'Callaghan v. Parker that said in order for the military, United States military, to have subject matter jurisdiction over an offense that a soldier committed, there had to be a connection, a military nexus, a connection between that, what they did wrong, and their required duties as a member of the military. This caused a very, very confusing situation, and the Supreme Court looked at it again in 1987, and they overruled O'Callaghan, and they passed U.S. v. Solario. And in Solario, they said, we're not going to have the military nexus test anymore. Now, we ask two questions. We ask, are you subject to the UCMJ now at the time of trial? And were you subject at the time you committed the offense? If the answer to both is true, then you can be prosecuted under the UCMJ. Now you'll say, we must be limited in the crimes because there are only certain crimes in the code. In theory, that's true. However, I've shown you two articles. Article 133 of the UCMJ, which is conduct unbecoming an officer, and Article 134, which is conduct to the prejudice of good order and discipline or service discrediting. Under these clauses, such things as violations of federal law, such things as violations of unit policies, almost any aspect of impropriety could in fact theoretically be charged if it is viewed as to the prejudice of good order and discipline or to the discredit of the service, or if it was viewed as unbecoming an officer. Thereby that's what Colonel Maxwell is viewing when he said that there's universal jurisdiction. Virtually any conduct could come under this. And we'll find later how this supports our holistic view. One thing I do want to emphasize, though, our military jurisdiction is not exclusive. For example, if a private in the Army is off duty and goes off post and commits an offense in Peoria, a town in the United States, he is chargeable under the UCMJ, but he is also chargeable for violating the criminal code of the state of Illinois. It is concurrent jurisdiction between a state and the military. If, for example, he was convicted of selling drugs, he could be tried in 3 different courts because distributing drugs could also be a federal offense. So he could be charged in state court for a violation of Illinois law, in federal court for a violation of federal law, or under the UCMJ for violating that code. One side note on double jeopardy, however, we have a clause that prevents you from being tried in more than one court for the same offense, or to be retried for the same offense. However, that would not apply when there are different sovereigns. So the military code and the federal courts are one sovereign. The state courts are a different sovereign. So there's been at least 18 times in history where an individual that has been tried at court-martial has subsequently been tried in a state court afterwards for the same conduct. I want to also jump to the third part of my slide up here about the significance of status-based jurisdiction. If you leave the service, the military can no longer prosecute you, even if you committed a military offense. If, for example, the day before you ETS, that is, end your time in service, if the day before you commit a military offense and then you are properly discharged, the following day, if they learn you committed that offense, the military does not have the authority to prosecute you. If you committed that offense, for example, if it was a disrespect offense, one that would not be chargeable under federal law or state law, but only under the code, then you could never be prosecuted. The jurisdiction of the military starts at the time of your enlistment. It ends at your final time in service. There is one caveat to that, and that is the Military Extraterritorial Jurisdiction Act. This was passed roughly 13 years ago, And what it did was, originally it was to fill a gap. When we had soldiers that were overseas that committed an offense and then ETS'd and returned to the United States. Well, the state and federal jurisdiction did not apply, and so they might have been charged, let's say they were assigned in Germany, they could have been charged under German law, but now they are back in the United States. So what we wanted to do was fill in a gap. And so if a soldier is overseas pursuant to military duties and commits an offense and then ETSs, so the military justice does not apply anymore, they could still be tried as a violation of federal law. Where this came into play recently is the case of U.S. v. Green, where there were 5, I believe they were Marines involved in a war crime. One of those, Green, was discharged about a month after the alleged offense for a medical condition. The other 4 were still in, and when they learned of the war crime, the 4 that were still on active duty were tried under the UCMJ. And Green was tried in federal court. And they received, the ones on active duty received sentences ranging from 90 years to life, and I think that Green in federal court received 5 life sentences. Although why you need more than one, I'm still not sure about. A quick rundown of who is subject to the UCMJ. As I mentioned, all active duty. Also, all of our students at our military academies are considered part of the military, and so therefore they are subject to the military, to the UCMJ. Military reservists are only subject to the UCMJ when they are performing military duties. National Guardsmen are a little bit unique. Our National Guardsmen are, in fact, part of a state military force. As you know, we are a federal government. Our federal government is of limited powers. Our state government is of general powers. And our National Guard is of a state military force under the control of the governor of that state. It can be activated. It can be called to federal duty by the president. If it is called to federal duty, then it also comes under the UCMJ of the federal government. If it is not called to federal duty, it comes under state laws and only state laws. You'll note that military retirees that receive pay, if you retire from the military, and we have a very beneficial retirement program after 20 years of active duty, you can retire for half of your salary. Military retirees, as long as they continue to receive that salary, are still subject to the UCMJ. I am retired from the military, so therefore I am subject to the code for the rest of my life. Anyone who is serving a court-martial sentence, even if their enlistment has expired, as long as they are continuing to serve that sentence, as in Leavenworth, the prison that Chief Baker mentioned, they stay under the UCMJ for the duration of their sentence. Also, we have prisoners of war, and that comes from basic international law, international humanitarian law. And then the one that Colonel Maxwell mentioned briefly, the case of Ali. This was a change in 2008, and this is civilians accompanying the force. Ali was an interpreter, and he was a unique individual because he was a native-born Iraqi who was a naturalized citizen of Canada. And then he was hired by the United States and trained as an interpreter to serve with the military during the conflict in Iraq. Ali got involved in a disagreement with another interpreter and stabbed that individual. He was actually charged with a violation of the Uniform Code of Military Justice. He pled guilty and received a 5-month sentence, and that conviction was in fact upheld by the Army Court. As mentioned, the authorization for status-based jurisdiction comes directly from our Constitution, where they are specifically authorized to create the rules and regulations for the land and naval forces. Although this is not the subject of my talk today, it is under the authorization of Congress to regulate or criminalize violations of the laws of nations. also under Article 1, Section 8 of the Constitution, that they have attempted to create our military commission system in the United States. The next thing I think is important for you to understand about the United States military is that we have a holistic view to justice. Remember I said that soldiers are always subject to the code. Not only are they just subject to the code, but they are constantly subject to a full array of administrative and non-judicial punitive actions. They can be reduced in rank. They could be denied the privilege of going off post or the privilege of going to the grocery store, the post exchange. They could be denied the ability to be promoted. They could be kicked out of the military. All of these various options, these commander's options that I have shown on the board, rest in a single individual, their first-line commander. However, I say single individual because there is a single line of command. And so your first-line commander, and then each commander above that in a single line has all those same authorities. A commander controls every aspect of your life when you are on active duty. Virtually, not quite a direct control of your personal life, but your ability to see your family can be controlled by the commander. We put a tremendous amount of trust in our commanders, and we look at it as a continuing spectrum. Whereas I think Brazil, which has offense-based jurisdiction, has a break. Commanders handle military activities, but then once the individual commits an offense, a separate judicial system takes over. It's important for you to know that ours is not a separate system. Our commanders control our justice system just like they control every other aspect of military command. And that leads us to the next area. Oh, I want to make one side note. As an idiosyncrasy of our system, if I understand it, in Brazil, after there's an investigation of an offense, the judge is notified and decides if there's probable cause to proceed with the action. Do you know who can prefer charges in the United States military? Any guesses? Anyone. Anyone that is subject to the UCMJ can prefer charges against anyone else. Preferral just means that they are, as an individual with personal information or having reviewed records, believe that a certain individual has committed a certain offense. And those charges are then forwarded to the commander, and the commander decides what to do with those charges. He could, in fact, say, I don't believe there is a basis for these charges. I don't think that this allegation is meritorious and that there is insufficient evidence to support it, and he could take no action. He could use the information contained in those charges to take adverse administrative action, or he could take non-judicial punitive action if he's a company-level commander. If he is a higher-level commander, he also has the option of referring the case to a courts-martial. So let's talk a little bit about that commander. Oh, excuse me, I also have, as the commander makes those decisions, he is informed, and every time a commander looks at every action, he looks at the full range of the options available to him, from no action to the maximum possible penalty that a court-martial could adjudge. And he must make an analysis over what is the appropriate action in this specific case. While he, of course, tries for consistency in his unit, he knows that the facts are different and every situation is subtly different. And so he must make a unique decision on each case. He considers the nature of the offense and the character of the accused, and he looks at the appropriateness of a specific punishment or adverse administrative action. And he will also, with the advice of his judge advocate, consider possible evidentiary problems. As you know, we have a very, very robust system of procedure and evidence in the United States. And many things, if they are collected in violation of our Constitution, such as in violation of the Fourth Amendment, an illegal search was done, or in violation of the Fifth Amendment, an interrogation was done without advising someone of their rights or without counsel present, that information, by our rules of evidence, could be excluded by the judge from consideration. So if that is the telling piece, the pivotal piece of information necessary for the conviction, then the commander will say, this is not a case that will go to court-martial. I could try to do it in non-judicial punishment. I could try to give an Article 15. However, a soldier has a right to turn down non-judicial punishment. A soldier can say, no, I do not want non-judicial punishment. I want to go to trial. And if that in case happens and the evidence is not admissible, the soldier would be acquitted at trial. Now I want to talk briefly about the commander and the predominant role of the commander. And for that, I've got to give a little bit of background about our culture. We are the first modern constitutional democracy. And we have one, I think, the most important part of our Constitution. And our Constitution requires all officers, to include all military officers, to take an oath before they can assume any role as an officer. And that oath says they swear to protect and defend the Constitution of the United States. Now think about that. They do not take an oath to defend 1 inch of land. They do not take an oath to defend one single citizen. No, our military takes an oath to defend the law. So why is it that we are so fixated on this document that is the Constitution? Colonel Maxwell mentioned his favorite president was John Adams. Mine is Abraham Lincoln. And Abraham Lincoln gave a famous speech following the Battle of Gettysburg. It's a speech called the Gettysburg Address, which almost every American child is forced to memorize at some time during their primary education. In it, though, he said a very powerful line. And I'm going to jump to that section. He says, "Brought forth on this continent a new nation conceived in liberty." Now, at that time, the word nation, and I think still today, referred to a group of people that shared a common language, common tradition, common history, and common religion. A nation. Well, the United States has never shared any of those. We have never had a single language. We have never had a single history. We've never had a single tradition, and we certainly have never had a single religion. And yet Abraham Lincoln said, we are a nation. Why? He said, we are a nation that is not bound by any of those. We are a nation conceived in liberty and bound by a law. Now, I am a German American, which means my ancestors came from Germany. And you can ask any American, and they will say, with the rare exception of the Native Americans, they will say where their ancestors came from. And we all know that. Because if our Constitution fails, there is no America. There is no American. If the government of France falls, there are still the French. But what makes us American is our dedication to that law. And no group of Americans is more dedicated to that law, I believe, than our military commanders, because they are indoctrinated and formulated in that. It is their raison d'etre. It is why they are officers. And I believe that these officers have a fantastic track record on the whole of preserving that Constitution. Since 20 years after the beginning, well, about 25 years after the beginning of our country, our military has had the capability of doing a military coup. But it has never happened. It has never been discussed. When Judge Baker mentioned MacArthur being relieved, MacArthur was incredibly popular among the military when he was relieved. And yet there was no military uprising. There was no rebellion against the president, because the foundational purpose of our military is to preserve the law. And the persons most responsible in preserving that law are commanders. Commanders are based on position, not on rank. If in a company of soldiers, roughly 130 to 150 soldiers, the commander is killed, the XO takes charge. But if all the officers are killed, the senior ranking enlisted person becomes the commander. And once they become the commander, their words create law. That is an incredibly powerful job. What I've done is I've given you a run-through of the authorities and the various levels we have of command. Each one, at the company level commander, has basic abilities to punish individuals at a minor level. For example, he can give an Article 15, a company grade Article 15, where he can reduce lower ranking soldiers in rank. He can reduce their rank. He can restrict them to a given area, saying you are not allowed to leave a certain area, for example, the unit area. And he can do various other administrative things, such as reprimand them, that would have a negative effect on their military career, but do not serve as true criminal punishment, since there really is, outside the military, no record of this document. At the battalion level, he has all the powers of the company commander, but he also has the power to refer to a summary court-martial. A summary court-martial is presided over by a military officer. This military officer does not have to be an attorney. The military officer evaluates the situation, but the maximum penalty of a summary court is 30 days incarceration. They cannot do, for example, they cannot kick you out of the military. At the brigade level, that is a commander of approximately 1,200 to 2,000 soldiers, depending on the brigade, he now can do a special court-martial. And in a special court-martial, he can confine someone for up to a year, but still does not have the ability to kick them out, to give them a punitive discharge. He can do administratively separate them, but he cannot give them a punitive discharge. It takes a general officer, and that is the person sitting, they must be sitting in a general officer position of command. Not every general officer has these authorities. Only those in a position of command can refer to our full court-martial or our general court-martial, which has the full range of punishment to include life imprisonment and even capital punishment. And they also have the ability to give punitive discharges. So what does our commander get to decide? When it comes to Article 15s, the commander decides whether the charges are sufficient to initiate the action, and that same commander serves as judge, jury, and executioner on those charges. He will evaluate whether there is sufficient evidence brought forward at a hearing to prove the charges beyond a reasonable doubt, and he will verify that proper rules are followed in his judicial process, and he will also then decide what the appropriate sentence will be within limitations. In the court-martial process, our judges, whereas yours are notified first, our judges have no role in the court-martial process until after it is referred to court-martial. So during the investigative process, or even after charges are preferred, all decisions, even what would normally be considered a decision that a judge should make, are made by the commander we call the convening authority. This commander has the ability to make rulings on whether certain evidence will be acquired. Like Colonel Maxwell mentioned that the defense has the right to call witnesses and have them produced. It will be the commander who will decide whether those witnesses will be funded or not and brought in or released from duty to testify. It is the commander that picks the jury. That seems rather counterintuitive, doesn't it? But no, it is because we trust in our commanders and their disinterest. It is our commander who decides whether to accept a plea arrangement. For example, a soldier could say, in exchange for a maximum penalty of 3 years, I will plead guilty to the crime. It is not our attorneys that decide whether to accept that deal, but in fact, our commanders. Even after referral, it is our commanders who decide whether to accept a guilty plea deal. The commanders also appoint our 32 officers, which is our civilian equivalent of a grand jury proceeding to investigate charges that might go to general court-martial. And they do a full and disinterested investigation of the charges, looking at the available evidence, and decide whether there's probable cause for that charge to then go to trial. Even after the court-martial is over, the judge is involved again, our commanders have the authority to set aside findings and say, even though the panel found this individual guilty, I am not convinced that this is appropriate justice, and they can set aside aspects of the findings. They can also grant clemency. The commander has the authority to reduce sentences if they believe that it is meritorious and proper. Moving from the commander to the trial itself, I think it's important you understand how adversarial our process is. In every single one of our courts-martial, the defendant is eligible, every single one of our special and general courts-martial, the defendant is eligible for defense counsel to represent them at the trial. They are assigned a defense counsel automatically, but they can also request a specific defense counsel if they would favor a different one. And if that individual is readily available, the person in charge of defense counsel could assign the one they request instead of the one that they originally assigned. They also have the option of securing their own civilian defense counsel. They, of course, would have to pay for that on their own, but if they do not want to follow with a military defense counsel, they could hire a civilian on their own. It's important to also note that our military judge and defense counsel, well, you'll see here, this was our old days. I want to give you a quick anecdote. When I came into the JAG Corps, we had something called the Lore of the Corps. The Lore of the Corps is we would talk, every year we would have a single reading that would celebrate everything that the Army JAG Corps had done in its history. And they talked about a time when the Army JAG Corps was still in its nascent stages. And the Army knew that it wanted to have a JAG Corps. And it knew that it wanted lawyers, but it could only afford one. So there was a time in the Army where there was only one judge advocate. And at a court-martial, that one judge advocate served as the prosecutor, as the defense counsel, and as the advisor to the judge. That's probably a little bit too conflicted. But these are, in fact, the old days. These are not the modern adversarial process. In the modern adversarial process, you have a right to defense counsel. You get the defense counsel advice for non-judicial punishment in summary courts, and you actually get represented by a defense counsel or a civilian in special or general courts-martial. You have the right to an Article 32, which, as Colonel Maxwell pointed out, along with our discovery opportunities, is more expansive than any other jurisdiction in the United States, is in giving the defendant the opportunity to have access to key information. You have, important to note that the judge and defense counsel are entirely independent of the military chain of command. So whereas the convening authority, the prosecutors work for the convening authority, the defense counsels are what we call a stovepipe organization. They answer only to defense counsels all the way to the chief defense counsel back in Washington, D.C. And judges follow their own chain of command, answering only to the chief judge back in Washington, D.C. Other idiosyncrasies that we have what is oftentimes discussed as the good soldier defense, where a soldier can defend a charge of an offense saying, rather than defend the actual allegation, can say, I want to present my military record. Look at how good of a soldier I have been. I am too good of a soldier to have committed this offense. We have a very professional military panel. This military panel ranges from as small as 3 to a maximum of 12. If there is a special court-martial, the minimum is 3. A general court-martial, the minimum is 5. And the maximum at all times is 12, but you are required to have 12 in the case of a capital offense where someone is tried and the possibility of capital punishment is there. This military panel is primarily officers. In fact, the default is it would normally all be officers. However, an enlisted soldier has the right to demand that 1/3 of the panel be enlisted. Now, it's important that you remember that it's 1/3. Other than capital cases, you do not require unanimity in our military panels. In other words, it does not have to be a unanimous verdict. You must have a minimum of 2/3 of the panel vote guilty for an individual to be found guilty. And that is 2/3 rounded down. So, for example, if you have 12 jurors, 8 and 9 would be required. 8 would be required. If you drop to 11 jurors, 11 panel members, you still require 8 votes to obtain a guilty verdict. I also want to briefly talk about the ethics of the military prosecutor. We are very adversarial, but I was a career military prosecutor. I prosecuted cases in 3 countries, and I was involved in roughly about 250 total. I will tell you that the last thing I ever wanted to do when I went to bed at night was to think that someone was convicted because of my skills as an attorney. So I looked at it as my job as a prosecutor, my ethics, to make sure that the defendant got the best defense they could. If I thought the defense counsel was making a mistake, I would ask for a recess, and then I would make sure the defense counsel knew exactly what they were going to do. For example, if they were about to ask a question that would open the door for me to get in some very damaging information for the defendant, I would ask for a recess and then explain that, are you sure you want to ask that question? I can remember vividly in one trial where the defense counsel, their entire case relied on an alibi defense. And the defense rested before putting on their key witness. And I could have proceeded saying, okay, but I said, asked for a recess, I asked the defense counsel, are you sure you wanted to rest? You forgot your key witness, and he went white, and I agreed to allow him to reopen the case. I did that because my goal as a prosecutor was justice. And I wanted to make sure that the defendant, if he was convicted based on law and evidence and nothing else. And I believe that that is a common ethic among most of the prosecutors in the United States military. The last thing I want to talk to you about is the thing where I think we're most similar. We have, similar to Brazil, a segregated system of criminal appeals. Although our courts-martial may be fundamentally different and organized, particularly in the role of the commander, I think our appeals process is relatively similar. First, this is an introduction to the general nature of our appeals, our federal appeal system in the United States. You'll notice here 94 districts. That's where the vast majority of federal appeals come from, is right here. But these are various other federal agencies that answer to the DC Circuit. But over here to the side, you have the service courts that answer to CAF, that's Chief Judge Baker's court, that answers directly to the Supreme Court. Similar to the Brazilian system, where you have the bulk, but then over here to the side, you have directly to this court here, which answers to your Supreme Court. I also want to note, because I mentioned our federalism system, just as a brief aside, the gray periods here, every one of our states has its own system of laws and its own court system. These courts operate outside the federal system. They operate, is this on? Yeah. They operate outside the federal system. So therefore, if you are charged in an offense in a state court, it will go all the way to your state Supreme Court and then answer to the U.S. Supreme Court if there is a federal issue. If it is only a state issue, the highest legal authority is that state Supreme Court. A quick introduction to our system. Okay. We have the Supreme Court of the United States, parallel with the Supreme Court of Brazil. Then we have CAF, which is equivalent to your Tribunal Superior. We have our service courts, which I think are, and our courts martial, which are roughly equivalent to your judicial circuits, and then parallel to our courts martials, our judicial councils. So as you can see, I think that in this area, as far as the criminal appeals, they're very similar. If you look, our Court of Appeals of the Armed Forces, you'll see that it is made up of exclusively civilians. They're appointed by the President, confirmed by the Senate, and they serve for 15 years. They have only appellate jurisdiction. There's no cases that start, or Judge Baker never presides over a trial at CAF. And they have mandatory review over capital offenses. Or if the Judge Advocate General, which is the highest military attorney in each branch, forwards a case specifically to them and asks for a ruling on a specific issue, they have to mandatorily review that issue. All other cases, CAF has discretionary authority. They decide whether they will take a case from any of the service courts and decide whether they want to rule on that issue or not. By parallel, you have in the Superior Court Tribunal Militaire, you have 15 ministers, 10 of which are military and 5 are civilian. They are also, however, appointed by the President, and they have, I believe, also both original and appellate forum on certain issues. And I take this from a dated article from the Vice President, but I believe that is still accurate. Our 4 service courts are based by our 4 primary branches. Excuse me, I appear to have, yeah, no, I did that. There we have our 4 service courts. We have the Army Court, which handles all cases arising out of the United States Army, the Navy and Marine Court, because no matter what Chief Justice Baker might tell you, the Marine Corps is actually just a subset of the Navy. And then we have our Coast Guard, probably our least busy court, service court, simply because they don't have as many people in the Coast Guard as the other services, and we have our Air Force Court. The reason we have specific service courts is because we want specific competence in the mission of that service. So the Army Service Court should understand more about the unique mission of the United States Army as compared to the other services, so they interpret cases relative to their understanding of that mission and those needs. Currently, these are only military judges, but in theory, you could appoint a civilian. Not sure who could appoint it. I just learned today that that's an issue before the court, but a civilian could serve on one of the service courts, but currently right now they are all held by military officers that are all judge advocates. All the members of the service courts are appointed by the Judge Advocate General, and they normally will come from judges, military judges that are serving in that service. The Army service courts they must review or they must look at every single court-martial that involves a sentence of death or a punitive discharge or a sentence for more than 1 year. So, what's the bottom line? I believe we share our purposes, and that is to create a system that supports justice while promoting and supporting the need for discipline. I think a big difference, however, is the fact that you have a status-based jurisdiction. I mean, we have a status-based jurisdiction and you have a offense-based jurisdiction, meaning that for us, anything a soldier does falls under the code. For you, it is various individuals could come under your code depending on what they do. We have a very fundamentally adversarial process with attorneys, military attorneys, on both sides of the aisle throughout the process. And we have a very holistic approach where we look at justice as a full spectrum of commander's options within a disciplinary realm. And finally, we have a very, very similar segregated appeals system. One thing I did also want to note is that our UCMJ does not really alter during combat or wartime. There are some modifications to some charges, and the jurisdiction over civilians deployed with a force must be to an area of combat. But other than that, we have the exact same system during war as we have during peace. So, what's my conclusion? Two different armies, two different judicial systems, similar in some ways, different in many others. I guess all I can say is, as my Mississippi brothers and sisters would say, there truly is more than one way to skin a cat.
Belíssima explanação. Eu mesma fiquei instigada em formular várias perguntas. Não vou fazê-lo, vou deixar para o público. E já tenho algumas em minhas mãos, professor. A primeira vem do capitão da Corregedoria, João Toledo, e ele pergunta: como funciona o processo de julgamento corte marcial quando os acusados são oficiais e praças? Concurso de agentes? Quantas penas de morte são aplicadas ao ano, bem como esta pena é executada? Modo.
Okay, I think I see that as two different questions, and thank you very much for the question. First, you're asking, how does the court-martial process differ for officers and enlisted? The disciplinary process is often different because in most military units, the ability to discipline an officer is pulled by a higher commander. So in most of the Army, for example, the General Court-Martial Convening Authority pulls the ability to reprimand an officer to his own level. An officer is only subject to, such as in Article 15, from a higher level commander. And let's see, an officer does not have the right to demand 1/3 of the panel be enlisted. And an officer, if they receive a punitive discharge, would receive a dismissal rather than a bad conduct discharge or dishonorable discharge. They would receive what is called a dismissal. There might be a couple other minor differences, but other than that, it is basically identical for both enlisted and officer. And the second part of that question?
Quantas penas de morte são aplicadas ao ano? E qual a forma de execução?
I do not, I will have to ask one of my compatriots, but I think it has been decades. Yeah, 1961 was the last time a military court-martial death penalty actually was carried out. I think that, and this is totally anecdotal, but my guess would be that we have a death penalty case where death is adjudged at the court-martial level maybe once a year, once every other year, more. Okay. So as Chief Judge Baker corrected me, there are only 5 or 6 total individuals on death row plus one death penalty case currently before his court. So that's not very many at all. And again, none have been, there's been no capital punishment actually enacted for a military since 1961.
Agora, a outra pergunta é da primeira-tenente Carolina Lindebark. O soldado pode mais de uma condenação pelo mesmo crime, aplicando-se o nis in nisium, que é vedado na legislação brasileira. Desta forma, cada pena é aplicada na sua totalidade ou existe algum tipo de senão ou limite para algum caso específico? E qual é a ordem para cumprimento de cada pena?
as I explained earlier, different sovereigns can, in fact, charge an individual with the same conduct. The conduct can give rise to a state crime and to a military crime. And at least 18 times in history, a soldier that was court-martialed was subsequently tried in state court. Normally, what you are looking at is a different nature of the offense. I had a case where an individual was drug dealing, and the civilian charge, the state courts, tried him and convicted him while he was on leave for drug dealing. And we did not find out about the charges until after we found out about the conviction. And he came back, and he had pled guilty and been sentenced to nothing but probation as part of a plea agreement. Well, we looked at that offense, and we looked at a couple other minor offenses with that, and we decided to, I believe we could have court-martialed the soldier, but we decided to chapter him out based on that. However, what I did have to research as part of that case is I learned that any sentence adjudged by the military is normally served first, and only after their enlistment has expired and they've completed their military sentence would they then serve any state sentence.
O Dr. Garcia, subprocurador-geral do Ministério Público, tem uma pergunta a fazer e disse que eu não conseguiria ler a sua letra. O senhor poderia fazer a pergunta, por favor?
Pois não. My congratulations for your excellent, objective, and clear explanation, Professor. Now, my questions, em português. Eu pergunto, aqui no Brasil, no nosso sistema da nossa Justiça Militar, é uma pergunta com relação à Polícia Judiciária Militar. Aqui, em cada caso, forma-se uma equipe de investigação presidida por um oficial. Agora, pelo que nós vimos de um filme estrelado pelo John Travolta, A Filha do General, nos Estados Unidos, pelo que vimos do filme, pelo que supomos, há um corpo permanente no Exército Americano de investigação que atua em todos os casos. Se realmente esse corpo existe, esse corpo permanente, e se ele se dissemina em várias regiões, regiões militares americanas, e a quem esse corpo responde, ou seja, a quem ele está subordinado.
Okay. I have to answer your question in a few different parts. First, I will tell you that we have, each of the services has two different permanent investigative bodies. One being some aspect of criminal investigation, such as there's a famous TV show in the United States called NCIS. And in the Army, the parallel is CID. NCIS is Naval Criminal Investigation Services, and the Army has Criminal Investigations Division. Both of those agencies are, again, what I refer to as stovepiped. They do not answer to local commanders. They answer to a separate command back, I think both are back in Washington, D.C. They investigate major criminal offenses. All of the militaries also have, within their military police, an investigation branch called, in the Army, it's called Military Police Investigations, that investigate minor offenses. But again, these are permanently assigned positions. That said, we also have two different types of ad hoc investigations. The first is the one I mentioned earlier. and that is Article 32 investigations. And that is the equivalent of our grand jury, where the commander would appoint a disinterested military officer to conduct an individual investigation. And that officer, with the advice of a lawyer, decides which witnesses they would like to talk to, and they conduct a hearing with both prosecutor and defense counsel there to evaluate whether the charges should go to trial. There is also what is called in the Army a 15-6 investigation. But this is a command-directed investigation. These can be either minor, such as a commander's inquiry, or a formal investigation, informal and formal 15-6 investigation. These are ad hoc. These are the commander, again, selecting an officer to conduct an investigation into an event. 15-6s are normally used by the command to investigate a large and sudden occurrence, such as a plane crash. You will normally appoint a 15-6 officer. You will appoint one officer to do a safety investigation, but a totally different officer to evaluate the conduct of all involved. And 15-6s are not merely the tool of discipline. They are the commander's ability to learn what actually happened. And so they have a broad range. We had a huge spike in 15-6s. 15-6s can be used to investigate where equipment has gone missing. 15-6s could be used to evaluate the conduct, non-criminal conduct, but improper conduct of a given military leader. 15-6s can be used to investigate why a given accident or incident occurred. But these, again, are ad hoc that are appointed by the commander with this purpose of investigating one specific incident, and when they are done with that, they are no longer an investigator.
A próxima pergunta é do Coronel Álvaro, de Angola. O senhor falou das opções que o comandante tem, e uma das quais, o de excluir o militar do realistamento. Gostaria que me fizesse entender se essas exclusões é sinônimo da expulsão. Se esse é o sentido, como se processa? Há uma instauração de um processo disciplinar? E se essas decisões é possível recurso?
Thank you for your question. Each of the services has a regulation that they use to control when individuals will be separated from service. And this covers all forms of separation, whether it be in reaction to negative misconduct or, for example, when I transferred from being an enlisted soldier to the ROTC, I also received a separation under this regulation. The separation authority is normally at the brigade commander level. So a company level or battalion level commander normally does not have the ability to separate a soldier. And then I have to separate soldiers into three groups. There are junior enlisted with limited experience. There are individuals with more than 6 years in the military, and there are officers. Officer separations are by a separate regulation, but in all three there are levels of due process. For the senior enlisted and for the officer, they have the right to a board proceeding. Whereas to the junior enlisted who have less than 6 years in service, they would not normally have a right to a board unless they are going to also receive a negative discharge, what we call an other than honorable discharge. These separation boards do not have the ability to give a bad conduct or a dishonorable discharge. They have only the ability to give an honorable, general, or other than honorable discharge. And the appellate authority is, again, within the command. This is not, you would not appeal a separation action to a judicial authority, but you must appeal it within the command. But the due process for those with the board would have the right to a full hearing where their entire military service is evaluated and the reason for their separation is evaluated. For example, even individuals who are being separated for a medical condition, if they have more than 6 years in, would have a right to this full board to evaluate their continued service.
Professor, receba nossos agradecimentos. Em nome do presidente dessa corte, o general do Exército Raimundo Nonato Siqueira Filho, da vice-presidente, a ministra Elizabeth Guimarães Teixeira Rocha, pela brilhante explanação e muito obrigada.
It's been my pleasure.